First, the chairman's comments about interviews, I think, misunderstands that the interviews do not occur during the I-130 petition stage or the I-360 petition page. The interviews occur in both cases at the I-45 stage when the individual seeks to get their green card based on the petition. So the point made by the chairman is simply incorrect. Finally, as to the what must be proven, the self-petition is much more rigorous than simply being the beneficiary of marriage to a U.S. citizen or lawful permanent resident. To have an I-130 marriage-based petition approved, you simply need to have proof of the legal marriage to the U.S. citizen or LPR. For the VAWA self-petition, you have to not only prove the valid marriage, but that there was battery or extreme cruelty on the part of the spouse, that you, the petitioner, have good moral character. So the additional evidence is proof of the valid marriage, the proof of shared residency, affidavits describing the abuse, corroborating evidence like police reports, medical reports, photos of bruises, proof of the spouse's status. It's much more rigorous. I would note that the request for evidence coming out of the Vermont Center for these petitions is much higher than the request for evidence for simply marriage-based petitions. 114% on average, every single petition filed has a request for additional evidence. I think, you know, the two portions of the bill that are particularly distressing is to violate the confidentiality that will expose victims to further abuse, as well as the really requirement that uncorroborated evidence be included. Now, these provisions will, and I can't believe it's the intent, but it's going to be the fact, these provisions would allow the abusers and criminals to use the immigration system against their victims. That is exactly the opposite of what this committee did in the years 2000 and 2005 when we drafted the confidentiality provisions. Many, if not most, of the women who are petitioning for themselves because of abuse are still residing with their abuser. Why is that? Because they have no ability to work, they have no ability to take their children anyplace else, and so their only way out is to get some status through this self-petition so they can get away from their abuser.
And the gentleman's time has expired.
And I would ask unanimous consent for 15 additional seconds. If, when they file that petition so they can get away from their abusive spouse, the spouse is notified, you don't think that they're going to go after that person even more? I don't think you have any understanding of how domestic violence works if you think that will not be the result. And I yield back since my 15 seconds is up.
Okay. The question is on the
Chairman,
gentleman from Florida. Ms. Adams is recognized.
Thank you, Mr. Chairman. Well, I've listened and I've heard a lot about this provision, and I just want to make sure that I'm clear. We cannot talk to anyone. We can just take whatever signature, whatever paperwork, and then it goes up to Vermont, and nobody else gets to talk or discuss this, is what I'm hearing. And that if I, in this piece of legislation, say that there will be evidence checked, and we will make sure, and if there's a face-to-face with the abuser and possible charges on this abuser, that will maybe lead to this abuser being incarcerated and unable to abuse someone else, that this is a bad thing. I am concerned about not only the current victim, but the future victims of these people, if in fact they are committing these crimes. But on the flip side, we have heard over and over again of numerous fraudulent claims which have happened. At a July Senate Judiciary Committee hearing on VAWA reauthorization, Senator Leahy invited a U.S. citizen victim of VAWA self-petition fraud, to testify. He heard her story, acknowledged the nightmare, that's his word, that she endured, noted that if there is fraud in the system, we want to get rid of it because it harms bona fide applicants. And I would agree. Unfortunately, he then introduced a bill with no provisions whatsoever aimed at fraud prevention in the VAWA self-petition process. He was correct, though. Fraud in the self-petition process hurts the true victims. The true victims. Immigration adjudication resources should not be wasted on fraudulent crimes or claims. So, let's just do a couple of examples here. Elena married a Dutch man who admitted marrying her for a green card 2 years into the marriage. After she refused to sign his final immigration papers, he attacked her at gunpoint and repeatedly threatened her if she turned him in. After hiring a retired FBI agent, she found out he was an inadmissible alien due to large-scale drug trafficking and that he lied on immigration forms, a felony. Neither thing mattered once he filed for a VAWA protection as a battered spouse. According to VAWA provisions, it's psychological abuse for an American spouse to withhold signatures on immigration documents. Now, who was the victim there? David found himself kicked out of his home one night when climbing in the bed. The police arrived at his door, handed him an emergency restraining order, and removed him from his house. David was confused since such allegations came out of nowhere. He didn't understand the nature of VAWA's immigration provisions or the incentives for his Russian wife of 15 months to use them. She feared that David regretted marrying her and might divorce her before she got her green card. He found himself further confused when an immigrant women's law center was on the docket for his domestic violence case, but that was his first clue as to his wife's true intentions. After living in a hotel room for 10 days, the charges were dismissed based on lack of evidence. Domestic violence allegations were never proven, but David paid alimony for 2 years. 3 years later, David is being deposed for a hauntingly familiar case. His ex-wife's new husband is facing similar charges, and she's going for alimony plus spousal benefits, military spousal benefits. Let's be clear on what the intent of this language is. It's to make sure that we do protect these victims. These victims are not being brought out into the light and just turned away. They have the ability to go to domestic violence shelters. They have the ability to work. They have the ability to continue to be protected and not have their identity or not their location released. This is not the intent of this legislation, to release that and put anybody in harm's way. And it's also to make sure that if we do have people out there that are victimizing people, that they should be held accountable, and so that they can't continue to victimize over and over again. Because which victim isn't going to be the lucky one to get out of that house? So when I hear this, I want to be very clear. This is to make sure that the victims that are real, true victims are going to get the assistance they need. And if there's fraudulent claims out there, let's take and deal with those. That's what the intent of this is, and that's why I oppose this amendment.
Mr. Chairman?
Thank you, Ms. Adams. The gentleman from California, Ms. Lofgren.
I'd move to strike the last word.
The gentleman is recognized for 5 minutes.
You know, we can do story, counter story, but the point is, in order to have your petition approved, you need corroborating evidence and that's why in 114% of the time, that's because there are multiple approvals and redos on this. You have to show evidence other than your affidavit. You have to show medical reports, police reports, convictions, and that's why only 63% of the applications are actually approved in the Vermont Center. You know, you've got, I'll give you an example where uncorroborated statements are used to undercut an actual victim. We had a case that USCIS told us about where an abuser submitted a photograph of his battered wife in a drab green work uniform that she had worn at a factory in China. The abusive spouse used that to claim that she was a communist and that it was a Communist Party uniform, and therefore she should be denied her petition. It turned out that it was just a uniform. It wasn't a Communist Party uniform, but he was trying to get her deported so that she could not participate in the prosecution of his violence. We had another situation where an abuser provided a tape that was disagreeing with all of the previous allegations made about domestic violence, turned out that it was the voice of the abuser's sister, not the victim herself. And if you just relied on these uncorroborated statements to decide the case, you're going to give the abuser veto power over the victim's status. That's not what we should be doing. And I'd like to talk just a little bit about those who are supporting this bill. There was an op-ed article in Roll Call last year, and it was authored by a group called SAVE, which is an organization that advocates on behalf of persons found to be abusers by government officials. They're supporting this bill. Ms. Spivak, Natasha Spivak, was the author, and turns out she's the owner of an international marriage brokerage company, which was recently on the losing end of a jury verdict upheld by the Fourth Circuit Court of Appeals, because she, the jury found, with a standard of clear and convincing evidence, that she herself had committed fraud by misleading a woman she'd brought into the United States from the Ukraine about the VAWA self-petition, and she did it to keep her success rate up on these marriage brokerages. You know, if you take a look at what commonly happens, and I'll just talk to you about a couple of cases that have come to my attention. A young woman who came to the United States from Haiti on a student visa and then married an American citizen. This is something that happens from time to time. Unfortunately, the American she married tried to kill her twice. He beat her, he strangled her till she lost consciousness. He left her for dead. He refused to file the petition for her so he could keep her under his thumb. And finally, she found out about the VAWA self-petition process. And so she did file it, and it was only after the petition was approved that she was able to move out. Now, her husband was so enraged that he told her attorney that when he found her, that he would kill her. If the husband, if the abusive husband had been notified when she filed the petition while she was still with him, she'd be dead. Talk about the Maria, whose husband was a legal permanent resident. She had 4 United States children. Her husband abused her, and again, she could not move outside of the house with her children. She found a lawyer, and to file the petition, they would meet at the laundry because she didn't want her husband to know. When she filed, her husband said if he found her, he would kill her. If the husband had been contacted for corroboration while she was still living there, she would be dead. This is a very common procedure, and you know, it just doesn't make any sense at all. You're being beaten, you're being abused, you're trying to get out of the situation, and under the bill, what does the government do? It tells the abuser that you're trying to get away from them. That is just completely wrong. This amendment would change it, and we ought to approve it.
Thank you, Ms.